Professor Raina Saab, we move to part 2 of the video presentation. First thing, I am curious to know that the aspects relating to documentary evidence, how should this be taught? Because to very many students it appears quite technical and difficult to understand as to what is the primary, what is the secondary, and admissibility of documents. So would you like to speak on that?
Documents are defined within the definitions of the Evidence Act. If we open the pages, it is at the beginning. So teacher should not attempt to teach documentary and this evidence at the beginning, except that he should superficially go that the evidence can be documentary as well as oral and other things, and should explain what is oral and what's documentary. Then he should move to section 56 and others where the documentary and oral are actually thrashed out. That's a long era. And oral evidence can be modified. We can take back certain statements, we can add to statements. Therefore, it is not the standard form of evidence in the sense, I don't say that it is not an evidence, but to depend completely on oral evidence, if the documentary is present, will not be correct. Documentary evidence is a permanent evidence because it is printed on paper. It is in India, it is tape recorded, whatever we say. It's a videographic. So in England, such things which are now electronics, that is tape, other videos and other things are known as real evidences. We in India have mixed the real with the documentary and we call it only documentary evidence. Therefore, documentary evidence is whatever is written on paper, which is videographic or which is in pictures, is a documentary evidence. It is difficult to erase that. That's why it is said to be a very important evidence and a very good evidence. Though the techniques are there of erasing it, but techniques are not so easy. It becomes doubtful if we erase it, then it becomes doubtful. But documentary evidence is important in the sense that it gives proof. If the documentary evidence is consistent, is very good. If it is not, we add oral and documentary together to make it correct.
One very interesting and important aspect is that while the moot courts prepare the students with regard to advocacy, how to address the court, what is usually very rarely done is the mock trial, which to my mind are important to teach, say, examination of a witness, whether it is the examination in chief, cross-examination, re-examination, etc. Now, the new faculty may be at a loss to understand how to organize this. With your long experience, what would you like to tell them how to practically demonstrate the examination of a witness to the class?
Unfortunately, in the syllabus of many universities in India, this chapter is omitted.
Quite right.
For teaching.
Yes.
That this examination part is omitted. But though it's very, very important.
Yes.
Part. And particularly to know what is examination in chief, what is cross-examination, who can do, to what extent he can do. These should be taught.
Yes.
And in moot courts, whatever the student is presenting before you, sir, is his own experience, not what he has been taught in the class. He has read it from the books, he is presenting in the moot court.
Now, the problem is that, say, for example, how to declare a witness as hostile, the expert witness, a child witness, or a parda nashin. How can these aspects be sort of explained to the students by the faculty?
The class?
Yes,
yeah,
in the class.
It's easy, but before I answer that, it is good. You have really said one thing is that what they present in the moot court is
really not connected to law of evidence at all.
Yes. The thing, but they try to do it, they mix certain things. But if you say to a teacher how to teach it, it is not difficult to teach it. That's why I said it should be localized.
Yes.
Law of evidence in these areas should be localized.
Okay.
So that the student will understand as to what is a parda nishin.
When you say localized, can you throw a little more light? What does it mean?
If I teach in Delhi, I can give 100 examples of a parda nishin.
Okay.
I can give examples of the localities where my Muslim brethren are staying.
Okay.
I can say anybody who is wearing the burqa is a parda nishin.
Right.
I can say if you live in Rajasthan and you have the people who have gungat, it's a parda nishin.
Right.
That's where she cannot see directly somebody before whom she is talking. So that's why I say localized. For a Rajasthani student, easy
Yes.
to understand. For a Delhi student, easy to understand.
Now, coming to, say, expert evidence, say a postmortem examination or a forensic handwriting. Now, these also need to be sort of brought home to the student so that it is there somewhere in his mind.
Sir,
How is this, or evidence of a child witness?
It's very important. For that, we should take groups of people to these mortuaries or to the place where the postmortem happens.
Okay.
Not only that, we have doctors attached to the hospitals.
Yes.
And I know in Delhi, he can come and deliver certain lectures on postmortem, how it is being done. But that is not being done, to be honest.
So the visiting faculty, the guest faculty should be called
from
for this.
the forensic areas.
Forensic
which was earlier very little, now it is a big brand.
Yes.
And now the universities which are forensic have been created. In Delhi also is one of the campuses. And those people should be brought in to give new fillip to the students about the new developments. Forensic has become a very important and integral part of evidence. Without it, no evidence, no case perhaps can be solved. Because cases become mysterious, and that whatever is hidden has to be brought out by the forensic evidence.
Perhaps you would agree that the mode of teaching, like role play, may be beneficial, that if one side is accused and one side is...
That's what I say. We say to this, the classroom meeting.
Yes.
The classroom meeting is to be introduced is difficult in the sense that it has not been practiced in faculties. Now, if a teacher practices, there is a teacher, 5 teachers teaching evidence, the person who will do it will lack in completing the course because he will be a bit slow than others. So if he is not slow, it should be introduced at the faculty level. So that instead of 45 lectures, it should be having 60 lectures.
Right. Your personal recommendation would be that law of evidence should be taught in one semester, or it should be there in 2 semesters?
No, it is enough to teach it in one semester.
It can be covered in one semester.
Because we don't teach much of it. Most of the things we don't teach. In the sense they are not necessary to be taught at that level.
Right.
But certain portions which we avoid teaching because time is short or the syllabus is too long, or the students are now the architects of everything. So we should not go by that. We should arrange important portions of evidence so that he becomes at least perfect man in the evidence.
Right.
The rest of the things he will learn by practice when he goes to the court of law. But whatever the things we have suggested or we have arranged, that forensic evidence, guest lectures, and attendance to other things should be the part of the teaching. Unless we integrate these things, we can't have a good lawyer in the sense of evidence.
My last question is that, say, if you were the dean of the law faculty, as part of the continuing legal education of the faculty, what would you sort of like to be organized, particularly for the law of evidence teaching?
Fortunately, I have been the dean.
Yes. So that's why I would like to sort of you to share your experience.
And I have been the Vice Chancellor
experience
also.
And lessons. Yes.
As Vice Chancellor, I was completely independent in the sense. At Himachal Pradesh National University, I changed the whole way. I was teaching that.
Kindly share your experiments and
teacher teaching the criminal law or the law of evidence or any law had to teach at least for 15 minutes in the class the practical part of it. So whatever you said before the lecture began or this video began was that it's necessary to speak to them that this is the law, this is the FIR, this is the copy of FIR. How is it being written? It's not that I think it is the duty of the lawyer with whom he will be the junior. It's my duty to say him that it is FIR, it is like this. These documents need at least to be shown to the students so that they becomes perfect. At least they can start earning the first step in the court of law. That is the bail application. No student knows it. He goes to the court of law. That's why he is being fleeced as a junior for many years. It's our mistake.
Right. So you would sort of advise the faculty as the Vice Chancellor that this is how the teaching, continuing legal teaching,
course need to be modified and revised every time. And these things need to be included whatever the developments take place. If we lose them, we lose many things.
Thank you very much, Professor Raina Saab. Your talk has been very illuminating, and I'm sure that the generation of law teachers would benefit from your discourse.
Thank you very much, sir.
Thank you.
Thank you.